A landmark decision at the Indiana Supreme Court could allow more than a third of Allen County's sex offenders to get off the registry.
In the case against a man named Richard P. Wallace, the High Court ruled it was unconstitutional to apply a new law to an old crime. Since then, the Indiana Department of Corrections has advised offenders to seek legal counsel if they think the Wallace case applies to their own cases. To have his or her individual case reviewed, the offender has to file a motion. News Channel 15's Megan Stemble joins us now with the story of one man who's in the middle of that process right now. It's our top story tonight at 6.
Joseph Rouse pleaded guilty to one count of child molesting for an incident that took place in early 1994. Rouse says he did so out of fear of losing his case. He completed his jail time, but says having to register as a sex offender has continued his punishment, and furthermore has punished his family, his wife Bobby and their 3 kids, including 2-year-old Michael. That's why it's so important now for him to be taken off the registry.
For my wife and for my children, I want them to be able to walk around without anybody saying anything about me derogatory towards them.
Rouse filed a motion with Allen County Judge John Surback. Surback forwards motions like Rouse's onto the county prosecutor. If the prosecutor agrees with the motion, an order will be sent to the Indiana Department of Corrections. That's the administrative body that runs the sex offender registry site statewide. Only officials there can remove an offender from the registry. The process can take anywhere from 90 days to 6 months, and it's possible that in the end, the offender won't be taken off the registry.
We don't necessarily have a quick answer to every situation, any more than we have a quick answer to every situation that arises in the courtroom.
For Joseph Rouse's family, the slow gears of justice are frustrating. However, they say it's very much worth the wait for a chance to start again with a clean slate.
I hope that any of the gentlemen out there that benefit from this do not ever hurt anyone again.
The Rouses initially had looked for an attorney to file this motion on their behalf. They found that attorneys charge about $700 to $2,500 for this action, but then they realized they could do it themselves and for free. So that's what they've done for the cost of parking downtown a couple times and a couple of copies. Now, the Wallace case on which the Supreme Court decision is based is really an interesting one, so be sure to head to our website, wayne.com, and click on this story. We have put a copy of the case there, and you can also hear bonus footage and interviews from county officials about this subject. Reporting in News Control, I'm Megan Stemble, News Channel 15.